Hi, my name is Amina Levy and I am the tax attorney at the law offices of Allen and Arcadier. I received a letter from Gabby Valdez in South Florida. She writes, "My husband's father doesn't have any income besides his Social Security and we are his entire support. Can we claim him as a dependent even though he is not our child and he is not living with us?" Hi Gabby, it might be easier to answer the question, who qualifies as a dependent? In the IRS code, there are two different qualifications for a dependent. One is a qualifying child, and the other is a qualifying relative. He would qualify as a qualifying relative if some other criteria is met. First, he cannot have over $3,400 in gross income. What that means is any money that he receives that's taxable cannot exceed $3,400. His Social Security is not taxable, so that does not count. So if he's receiving only Social Security, he then qualifies to be your qualifying relative. Another thing is he does not have to live with you if you are supporting him for over half of his support. However, I would contact a local tax attorney to be sure. Similarly, if you have a child who receives Social Security income from a deceased parent, that child could still qualify as your dependent. If your child is receiving less than half of the support that you're offering him or her, and by support I mean the rent or mortgage you pay on your home, the food that you pay, the utilities, driving him or her to and from school, soccer expenses, basketball expenses, clothing. If your child is getting more than that in Social Security income, then that child is not your dependent. Your child will need to file his or her own separate tax return. However, that child will not be liable to pay taxes because Social Security income is exempt from taxation. Contact a local tax attorney to be sure.